my name is Heather, and this is another Delphi update. So, we are going to be reading through another court document, and this one, as you can see by the thumbnail, I titled it "The Defense Does Judge Gull's Job for Her," and you'll see why as we read through it. So, this is the defense's reply to the prosecution's response to the third Frank's memorandum. And I'm going to premiere these two videos like back to back. So if you didn't see the state's response to the defense's third Frank's motion, then you might want to go and check out that video before this one just to see what they are responding to. All right, so we are going to begin. Comes now the accused, Richard Allen, by counsel Andrew J. Baldwin, and files his reply to the prosecution's response to the third Frank's notice. In support of said reply, the accused states the following. Number one. Oh, and before we get deep into it, can you please like this video, subscribe, share, comment? All of those things really help this channel, and they help the algorithm, and it'll also help you in what YouTube thinks videos in the recommendations of the videos that YouTube gives you. So anyways, thank you so much for being here. Let's dive in. All right, so the one area of agreement with the defense and prosecution is that in order for a Frank's hearing to be granted, the defense must provide a preliminary showing that false information contained in a search warrant affidavit was either intentionally included or included with reckless disregard of the truth, such as Liggett's claim that in 2017 Sarah Carbow identified the man walking down 300 North as Muddy and BLOODY and is wearing a blue jacket in order to assist the state's timeline, when in fact Sarah Carbow never mentioned the word BLOOD at all, and she identified the man's jacket as tan and not blue. So, big differences in what Liggett said her statement was and what her actual statement was. Number two, additionally, the defense must provide a preliminary showing that important information omitted from the search warrant was intentionally omitted from the search warrant or was omitted with reckless disregard of the truth, such as the Liggett's failure to include in the affidavit that Betsy Blair's description of the vehicle at the CPS building was a non-black vehicle that resembles a 1965 Comet with sharp angles, which looks nothing like Rick Allen's car, as his was black and was a modern car, like a Ford Focus or something like that. Or Liggett's failure to include the description of the person Betsy Blair observed on the bridge as being as young as 20 years old, who had brown poofy hair, which looks nothing like Richard Allen. Or the failure of Liggett's to include the fact that Brad Holder had a photograph on his social media that mimicked the crime scene before anyone knew about the crime scene, among other facts that Liggett omitted in his affidavit. Number three, the defense would not expect Tony Liggett or any law enforcement officer to voluntarily admit that he either intentionally provided false information or omitted information with reckless disregard of the truth. It's not like a law enforcement officer is going to be like, oh yeah, I lied. I lied in that report. And, sorry, I don't know. They're not going to admit it. You have to bring it to a hearing, bring the evidence to a hearing so that you can judge for yourself and find out if Liggett is a trustworthy witness. All right, so number four, because Tony Liggett is not likely to freely admit that he provided false information or omitted information with reckless disregard of the truth, in order to prevail at this preliminary stage, the defense has provided evidence in Franks 1, 2, and 3 that throughout the investigation, and even after charges were filed, that law enforcement has provided false information or attempted to conceal information. Yikes. Yikes. Okay, so number 5. If this court expects or requires the law enforcement admit to intentionally or reckless disregard for the truth, then a Franks hearing is nothing more than a legal fiction. 6. In providing evidence of law enforcement and prosecution attempts to conceal evidence throughout the case, the defense is providing the court the opportunity to reach the logical conclusion that if law enforcement and the state of Indiana has attempted to conceal information in 2023, then it is reasonable to conclude that law enforcement also concealed evidence or provided false information intentionally or with reckless disregard of the truth in the 2022 search warrant affidavit, which is the one that is ultimately was used to search Rick Allen's house. Number 7. The defense has provided evidence that throughout the history of this case, but particularly in 2023, law enforcement and or the prosecution have presented false information or attempted to conceal evidence. Again, the purpose of providing said evidence is to provide the court the ability to question law enforcement's intentional or reckless disregard of the truth. Like, we're being called, like us, we, the defense team, we're being called liars. Let us have our evidentiary hearing so that you can determine yourself if there is something to this angle with the Odinist ties and Brad Holder and all this other stuff going on. And the lies that, were going on within law enforcement and things not going anywhere after they got to unified command. So those are the things that need to be searched out in an evidentiary hearing and find out why and what's the reasoning. All right, number 8, below, this is where I said the defense does Judge Gull's job for her. Below is a proposed order granting Franks hearing, which is intended to assist this court in that it ties many of the defense's factual and legal arguments into language that expresses why this court should grant the defense request for a Franks hearing. So if you're not going to do the work, and if you're not going to read through all the crap that I have put together for you in this for requesting a Franks hearing, I'm going to just put it together for you. So it's a boilerplate. So you can, change it up if you want, but here's what you can use to grant us this Franks hearing. I think this is hilarious that they did that. They did Judge Gull's job for her. So order granting Franks hearing. Comes now the court, having reviewed the defense's third request for a Franks hearing, as well as the response of the state of Indiana and the reply of the defense to the state of Indiana's response. As requested by the defense, the court also reviewed the contents of Franks 1 and 2, and also all the exhibits, and lastly, the exhibits this court received on April 5th. Oh, so they received some more. 2024, so just probably with this document that the defense sent overnight and identified in their reply brief filed on April 3rd. Ooh, I wonder what that is. I don't think we've seen that. And the court, being duly advised on the premises, now finds and orders the following. Remember, this is the defense writing it as if the court were issuing it. So it's like here, let me help you do your job. The court, having watched the 2017 videotaped interview of Sarah Carbow, finds that the defense is correct in claiming that in 2017, Sarah Carbow never said BLOODY when describing the clothing of the man that she observed on the road. The court also finds the defense was correct in stating that in 2017, Sarah Carbow never said the man was observed wearing a blue jacket. In fact, Carbow described the color of the jacket he was wearing as tan. The court finds, therefore, that Tony Liggett provided false information in his search warrant affidavit, and this false information materially affected the timeline the state of Indiana advanced in its search warrant affidavit. Additionally, the court, having watched Betsy Blair's videotaped statement and having reviewed other evidence provided by the defense, finds that Betsy Blair described the man that she observed on the bridge as being in his 20s and having brown, poofy hair. This description does not depict the way that the defendant, Richard Allen, looked in 2017 according to his age and according to how his wife described how he always wore his hair very short, almost shaved. Furthermore, the court finds that Betsy Blair described a vehicle that was not black and therefore resembled the 1965 Mercury with sharp angles. The court finds that Richard Allen's Ford Focus was black and did not resemble the 1965 Ford Focus, or whatever car it was, whatever car it is. So the court further, I don't know if they meant to say Ford Focus there. Anyways, the court further finds these omitted facts were central facts necessary for establishing law enforcement's timeline of Richard Allen's involvement in the crime. The court finds further that should Judge Diener have known those false and omitted facts, that he would have refused to sign the search warrant, as they are the types of facts that a judge would want to know more before signing the search warrant. As those factually material affect, as those facts materially affect the timeline in such a way as to show that Richard Allen was not on the bridge, nor was his car parked at the CPS lot, and was therefore not the man that committed the crimes. However, law enforcement providing false information or omitting crucial information is not enough to require a Franks hearing. The next step is for this court to determine whether Liggett made these false statements and omissions intentionally and or with reckless disregard of the truth. The court recognizes that it is unlikely that Tony Liggett or any law enforcement officer will voluntarily admit that he intentionally provided false information or omitted information with reckless disregard for the truth. However, in this case, the defense has provided evidence by way of police reports, emails, photographs, videos, and audios that the defense claims show multiple occasions in which law enforcement provided false information in 2023 and or tried to conceal evidence in 2023. Just a few of those examples include the following. The defense provided an August 10th, 2023 deposition of Jerry Holman, in which Holman claimed that a Purdue professor stated that it was not Odinism or any type of cult worshiping that would have conducted the crime. However, the defense has since provided evidence that Jeffrey Turco never made such a statement. In fact, when asked at his March 21st, 2024 deposition if he, Turco, ever uttered the words to the police that based upon his findings, the sticks were not Odinism or any type of cult worshiping, Purdue professor Jeffrey Turco stated the following under oath: "That was not a hypothesis that I asked to weigh in on the 2017 and certainly to weigh in on in 2017 and certainly would have declined to do so." I don't know, whatever. All right, so when comparing Holman's deposition with Turco's deposition, at best, Holman did not provide accurate testimony. At worst, Holman lied under oath. Okay, so in his deposition, Holman explained that based upon the Purdue professor's statement that those involved in Odinism were not involved in the crime and therefore his investigation into Odinists was essentially abandoned. Holman's statement has been proven to be false in that the Purdue professor never claimed that it was not Odinism or any type of cult worshiping that would have conducted the crime. Holman's inaccurate deposition testimony is troubling to the court. Furthermore, the defense claims that for several weeks following Holman's August 10th, 2023 deposition, that the defense had been requesting the identity of the Purdue professor whose findings, as mentioned by Holman and Liggett, essentially redirected the investigation away from Odinism. The defense wanted to conduct a deposition of the Purdue professor to confirm the accuracy of the claims made by Holman and Liggett of the Purdue professor's conclusions that Odinists were not involved in the unalivings. The defense made multiple inquiries to McLeland over the course of August and early September as to whether the Purdue professor had been identified. Each time, McLeland said that the Purdue professor had not yet been identified. The defense has since provided an email to the court that Prosecutor McLeland sent to the defense on September 6th, 2023, in which he claimed, quote, as stated before, we are trying to identify the Purdue professor, but no luck yet. Detective Holman has reached out to the FBI and Purdue and has not gotten a response yet. Okay. We will continue our endeavors, but we may not be able to identify him or her. However, a September 22nd, 2023 report drafted by Jerry Holman and provided to the defense in February 2024 tells a different story and contradicts McLeland's words in that September 6th email. In his September 22nd report, Holman admitted that the Purdue police had informed him that the Purdue professor's name might be Turco. Holman knew this information as early as August 12th, 2023, and no later than August 14th, 2023. Furthermore, in Holman's 9/22/23 report, he says the following: I notified Prosecutor McLeland that I possibly had identified the Purdue professor. He, McLeland, requested that I meet with the professor and verify that he was the one that provided the report. This conversation between Holman and McLeland occurred, according to Holman's report, sometime on or before the 14th. So what is he says? Let's read that again. So furthermore, in Holman's report, he says the following on. He knew this on or before the 14th of August. I notified Prosecutor McLeland that I possibly had identified the Purdue professor. He requested that I meet the professor and verify that he was the one that provided the report. Yeah, that's pretty damning. Okay, so therefore, McLeland knew for at least 23 days that Holman had possibly identified the Purdue professor as Turco, yet despite having this knowledge, McLeland not only told the defense team that Holman had no luck in identifying the Purdue professor, inexplicably, McLeland claimed to the defense that we may not be able to identify him or her, which is very strange. And yet you contacted the FBI to find out who it was, but you'll never be able to find out who they are, even with the FBI's help. Okay, buddy. A few days after August 14th, 2023, law enforcement received Turco's 2017 report. In the first paragraph of said report, Turco wrote the following: the argument that these markings, the sticks, constituted an inscription inspired by Norse runes or modern recreation thereof is quite plausible, contradicting Holman's sworn testimony. However, said report was not received until the defense made a request to McLeland on October 4th, 2023, around 45 days after law enforcement claimed to have located the report. Clearly, on September 6th, 2023, McLeland had been fully aware for over 3 weeks that Holman had learned the possible identity of the Purdue professor, being Jeffrey Turco, and by then had even received the unsigned 2017 report of that professor. Yet McLeland claimed to the defense that the FBI and Purdue police had not yet responded to Holman when clearly both had, even providing the name Turco to Holman. In spite of this knowledge, McLeland then refused to alert the defense of the name Turco, nor provided the defense with Turco's 2017 report, but instead told the defense that we may not be able to identify him or her. I mean, that's pretty damning, especially the way that they just laid it all out like that. McLeland, the elected prosecutor, was not forthright with the defense when he told the defense that the prosecution was not aware of the identity of the Purdue professor. The court also notes that Nick McLeland was a signatory on the search warrant affidavit, meaning he signed on the affidavit. So he was there when Liggett was trying to get the affidavit signed by Judge Diener, approving the language contained in the search warrant affidavit. So he approved the language. The court also concludes that if Nick McLeland was willing to attempt to conceal the identity of the Purdue professor in the September 6th email, that it is logical to conclude that as a signatory approving the language contained in the search warrant affidavit, McLeland might also be willing to fabricate or conceal other evidence in that affidavit. Bam. Whoa, okay. This is great. I knew this was going to be spicy, but this is really good. Additionally, having listened to Holman's September 19th, 2023 interview of Turco and reviewed the transcript, the court also finds that Holman's report memorializing that interview was misleading in terms of what Turco actually said. It appears to the court that Holman was minimizing Turco's claims that it was a given that the sticks were left behind by someone attempting to replicate a Germanic runic script. Holman's report never mentions the word rune one single time and makes it appear as if Turco was claiming that his findings were inconclusive as to whether the sticks were even formed as runes. In fact, the recordings make it clear that Turco never questioned whether the sticks were formed into runes. Turco only questioned the intended interpretation of those runes. Additionally, the defense provided evidence that on May 1st, 2023, Prosecutor McLeland received from law enforcement officer Todd Click a certified letter and packet containing exculpatory information. Furthermore, the court finds that McLeland did not immediately turn over that exculpatory evidence to the defense, but rather waited 4 months before turning it over, and only after depositions were conducted in which the prosecution likely determined that it was obvious that the defense would learn of the existence of the exculpatory evidence as Todd Click was expected to be deposed. So Todd Click, remember, he is one of the good guys in Delphi. So Todd Click, Murphy, and Ferenczi, there were 3 officers, Murphy, Ferenczi, and Click, that even though Unified Command stopped looking into the Odinist ties, those 3 continued to look into it. Ferenczi ended up losing his life in a mysterious assassination outside while he was on duty. So I don't know the details on that, and it seems mysterious to me. Maybe he got too close. Maybe he knew too much. I don't know. But if you are interested in what Todd Click has to say, I'll put it in the description below, a link to the transcript reading of the May 18th hearing of the motion to dismiss based on exculpatory evidence being deleted by law enforcement. And Todd Click is on the stand, and he says some very interesting and enlightening things. So if you're interested, that is on my channel as well. All right, so 3 law enforcement investigators named Click, Ferenczi, and Murphy believed that their investigation revealed evidence that third-party suspects involved in Odinism committed the unalivings. This is consistent with the defense theory in the prosecutor's response to the defense. The prosecution claims that the defense is continuing to make up a story about Odinism being involved in the unalivings. Like I titled my last video, McLeland is claiming that the defense is making up the Odinist theory. And they say they have no claim or no evidence to back up an Odinist tie. But we have all this stuff in court documents that it already appears that it is very clear that it could be true. All right, so anyways, where did I leave off? In the prosecutor's response to the defense, the prosecution claims that the defense is continuing to make up a story about Odinism being involved in the unalivings. However, the very evidence that the prosecution attempted to keep from the defense for over 4 months contains evidence that 3 law enforcement officers involved in the investigation support many, if not most, of the findings and theories of the defense. So 3 officers, 2 sets of reputable defense attorneys now, and what more is it going to take? 3 reputable officers in good standing and 2 very distinguished sets of defense attorneys that all are seeing the same thing. Law enforcement actually supporting the theories of the defense is highly unusual and highly exculpatory. The prosecution failed to turn over the evidence in a timely manner. Certainly, the failure of the prosecutor in 2023 to immediately provide this exculpatory evidence to the defense attorneys allows this court to draw the logical conclusion that Tony Liggett, who signed the search warrant affidavit, and Nick McLeland, who, with his signature, approved the search warrant affidavit, would be willing to hide evidence from Judge Diener in 2022 when drafting and approving the search warrant affidavit. That's great logical conclusions, and the way that he's laying this out is great. All right, letter D. Furthermore, the defense provided the deposition testimony of Tony Liggett, who swore under oath that he believed evidence supported that only one man, Richard Allen, committed the crimes, and therefore it could not be a group of Odinists that committed the crimes. However, the defense also provided the deposition of Tobe Lesenby, who testified under oath that he believed that more than one person was involved in the unalivings because it would take more than one person to commit the crimes. Furthermore, Lesenby testified under oath that Tony Liggett in private conversations agreed with Lesenby that more than one person was involved. This conflicting deposition testimony by the man who authored the search warrant affidavit, Liggett, provides evidence of attempted concealment, that multiple people were involved in the crime, and therefore supports that Liggett intentionally provided false information and concealed information in his 2022 affidavit for search warrant. It is logical to conclude that if Liggett provided false evidence or testimony in 2023, he could have provided false or concealed information in 2022 when drafting the search warrant affidavit. I mean, these are all great logical conclusions here. While the defense has offered several other examples of law enforcement's false or misleading or concealed information throughout this investigation, those examples identified in A through D above are enough for the court to order a Frank's hearing, as at worst it appears that law enforcement and or the prosecutor intentionally fabricated evidence and or concealed evidence. At best, there is an appearance that law enforcement and the prosecutor attempted to falsify or conceal evidence on several occasions. Not just once, but multiple times. So that's a problem. The court therefore finds the following. A. Tony Liggett, who signed the search warrant affidavit, and Nick McLeland, who approved the search warrant affidavit, provided false information in the affidavit, particularly as it relates to the 2017 statement of Sarah Carbow affecting law enforcement's purported timeline. I read all that in one breath. And there was no punctuation there. All right, so Tony Liggett and Nick McLeland omitted certain information, important information, in the search warrant affidavit as detailed herein, particularly concerning statements of Betsy Blair. Said omitted information also affected law enforcement's purported timeline. The defense provided several examples where law enforcement and or the prosecutor fabricated certain evidence in deposition testimony and emails and or attempted to conceal certain information from the defense, such as the identity of certain witnesses or certain mimicked crime scene photos like Brad Holder had on his Facebook and Albus Fields and whoever else, or failed to provide exculpatory evidence in a timely manner. As it is logical to conclude that if in 2023 law enforcement and or their prosecutor has fabricated falsified information with the course of a case or has failed to timely produce exculpatory evidence in the course of a case, that it is possible or even likely that law enforcement and or the prosecutor signing off on the search warrant affidavit, either intentionally or with reckless disregard of the truth, provided false information and or omitted information in the search warrant affidavit that was drafted just the year prior in 2022. All right, so wherefore the court grants the defense request for a Franks hearing and orders a Franks hearing to be set at a time to be determined by the court. The state of Indiana, okay, so that was a great example of what they would like Judge Gull to come forth with in her orders. But will she do that? I seriously, seriously doubt it. But we'll see. It's going to be interesting to see how she responds to it now, because they've told her, like, this is what's happening and this is all. I mean, how can you deny? These were Baldwin, Rosie, and Hennessy, I think, are really good lawyers in that the way that they're responding to the case in their motions, it also helps, like, helps with the public disseminating actual factual information about the case rather than, you know, the garbage that the mass media spews out. All right, so where was I? All right, so the state of Indiana has accused the defense of making false statements in a continued effort to support the theory that those involved in the unalivings were also involved in Odinism. The prosecution has also indicated its confusion as to why Jerry Holman's 2023 attempts, as alleged by the defense, to hide the identity and findings of Purdue professor Jeffrey Turco have anything to do with a search warrant affidavit that was filed in October 2022. The words contained in the proposed order granting a Franks hearing in paragraph 8 have should answer the prosecution's questions as to how Holman's 2023 interview of Turco applies to a 2022 search warrant affidavit when factoring in the requirements of a Franks request. Law enforcement's concealment of evidence in 2023 supports the intentional or reckless concealment of evidence and false information in the search warrant affidavit of 2022, which is where they were trying to get, and I felt so bad for Baldwin when reading through the transcript from May 18th. These were the connections he was trying to make through the witnesses, but McLeland kept objecting. The state kept objecting, saying, like, I don't see the relevance and how this is related and blah, blah, blah. And, of course, Judge Gull kept granting or sustaining their requests. So I don't think he ever got to make the actual connection in his arguments through his witnesses, I should say, through questioning his witnesses. So here it is in his court filing, which helps to clear up the record, I think, at least, especially for us, because he was trying to make these connections and he was prevented from doing so because Judge Gull is biased. All right, so where did I leave off? Holman's Turco replied to, I think I left off here. So Liggett and Holman are both tenured members of the Unified Command. McLeland is the prosecutor who signed off on the search warrant affidavit. All three, Liggett, Holman, and McLeland, as shown in paragraphs A through D above, have attempted to conceal evidence throughout this case or made statements under oath that have been found to be inaccurate, misleading, or false. As far as the prosecution's claims that the defense has made false statements in a continued effort to support its theory that those involved in the unalivings were also involved in Odinism, the defense offers the following. Oh boy, let's buckle up. Local rule required the state of Indiana to produce evidence to the defense by December 14th, 2022. Beginning September 8th, 2023, until October 6th, 2023, days before the prosecutor requested the defense get kicked off the case, the prosecutor finally turned over 14 hard drives, several thumb drives, and certain discovery. Oh, okay. This court has not yet chastened the prosecution for its incredibly late discovery, which the defense has detailed in previous filings. Yeah, why aren't you getting on Nick McLeland's case for the things that he has not been doing correctly or has been intentionally doing incorrectly? The state of Indiana incredibly blah, blah, start over. The state of Indiana's incredibly late discovery of exculpatory and other important evidence has put the defense in a continual bind in terms of preparing this matter for trial and preparing for depositions with all the evidence the defense would need for complete deposition preparation. The court has not found the state's failure to follow the local discovery rules as either intentional, negligent, or grossly negligent, even when the defense has provided evidence to the court. So why aren't you finding the state being negligent? Both the prosecutor and law enforcement. All right, so that the prosecution delayed turning over exculpatory evidence provided by an investigating officer for more than 4 months after McLeland received that evidence and only turned it over when the prosecutor knew that it was inevitable that the defense would learn of the existence of this exculpatory evidence. To this date, the prosecutor has still failed to explain this 4-month delay. Again, the evidence the prosecutor failed to turn over to the defense involved the findings of 3 seasoned investigators, including one that worked alongside the FBI, who all supported the theory that Odinists were involved in these crimes. This theory is not just conjured from the imagination of the defense lawyers to gin up public sentiment, as suggested by the prosecution. It is a theory supported by multiple law enforcement officers who investigated this case. Much of the late discovery the state of Indiana finally turned over in September and October 2023 was exculpatory in nature, including several interviews that the defense had been requesting that were key parts of the Odinism theory that the defense was pursuing, including interviews of Elvis Field, Johnny Messer, and Rod Abrams. Included in this discovery, received nearly 10 months late, was Liberty German's phone dump, including the famous Down the Hill video. This phone dump contained very interesting information that the defense had approximately 1 month to investigate before the prosecutor requested the defense to be kicked off the case. The defense should have had this key piece of evidence to review and provide to its experts no later than December 14th, 2022. On or about October 6, 2023, the defense received geofencing evidence. The prosecutor requested the defense kicked off the case only days after the defense received this evidence. So they got the geofencing and then boom, off the case. So you get this geofencing data that proves that there were 3 other individuals in this area, at least, with their cell phones on and pinging in these areas where the crimes were supposedly to have happened right at that time. So either these people must have seen something and never came forward, or it didn't happen then when the state says it happened, or those people are the perpetrators. So I mean, it really, it's one or the other, because otherwise it just doesn't make sense. All right, so is that the geofence? Yeah. All right, so after the Indiana Supreme Court reinstated the defense team received the geofencing data in the form of charts and a map on or about January 30th, 2024. The defense then took that information to its expert for review. Because of the prosecutor's late discovery of the geofencing evidence before getting kicked off the case, The defense only had the geofencing evidence for 6 days before this court ordered the defense to stop working on the case. Again, almost 10 months late. After getting back on the case, the defense has now had just over 2 months to analyze this important evidence along with all the other evidence it has received. The defense should have had this evidence on or before December 14th and therefore is doing its best to analyze this geofencing data and has based its interpretation of said evidence on its technology expert who was providing opinions without the benefit of law enforcement reports that interpret the data. It appears that law enforcement has not written a single report that interprets their geofencing data. Interesting. The court has since denied funds for the defense technology expert to conduct further analysis on the geofencing data. The court has denied funds for the defense to look at the expert, or to hire experts to look at the geofencing data. That makes no sense. Attempting to understand the geofencing data, the defense asked for many reports from law enforcement that interpret the data and map that the defense located in discovery. The prosecutor claims that no reports or notes exist related to geofencing, but the defense can't be sure. In the past, the prosecutor told the defense that no notes or reports existed as it related to Liberty's phone or her phone dump, only to then be handed notes from the prosecution's law enforcement expert minutes before the deposition began, giving the defense little or no time to incorporate those notes into its deposition preparation. Are you kidding me? Wow. All right, so when the defense asked for the names of the geofencing expert that the prosecution would call, the prosecutor initially refused to identify their expert, claiming it was not his job to provide that information. The prosecutor then stated he would talk to his investigator, Steve Mullen. Then, rather than simply identify the law enforcement officer who analyzed that geofencing evidence, the prosecutor provided the names of 4 possible experts that refused to identify which one was the geofencing expert that had actually analyzed the evidence. What? Weird. That's crazy. So they're trying to find out who their expert was so they can get reports and all that, and they were not giving it out to them, not telling them the information. And then when they did give them anything, it was these other experts that refused to identify which one of their geofencing experts had actually done it. This is so weird. That's so weird. I don't know. It's like no one wants to claim the lies, the fabricated work or something. I don't know. Now, apparently, in his response motion, the prosecutor is claiming there are 3 geofencing experts he may use, but still has not identified which expert put the map together or provided him the information he used in his response brief. In his response motion, the prosecutor also provides purported information that he has apparently obtained from one of 3 law enforcement officers who apparently has analyzed the data and relayed the information to the prosecutor, thus providing proof that the prosecutor has actually known the name of the exact geofencing expert who will be explaining law enforcement's interpretation of the data, but just has refused to provide the name of this specific geofencing expert to the defense. So they're hiding their expert from the defense for some weird reason. Rather than simply identifying the proper law enforcement officer for the defense to depose concerning the geofencing evidence, again, evidence that the prosecutor provided to the defense 10 months late, who put the map together, the prosecutor continues to conceal the identity of the actual expert, only narrowing it down to 3 possible candidates. The defense has no way of knowing if anything, back up. The defense has no way of knowing if anything that the prosecutor claims concerning the interpretation of the geofencing data is correct because no reports have been provided that substantiate the prosecution's claims in his response to the third Frank's notice. Please notice on pages 2 and 3 of his response briefs that the prosecution has failed to provide the name of a single authoritative report that supports his claims as to the accuracy or inaccuracy of his geofencing data, while the defense has provided 126 exhibits to back up their claims in Frank's one alone. Damn, I knew this was going to be spicy. Apparently, the prosecution simply expects this court to rely on and believe in the prosecution's claims or clams that he, the prosecutor, has asserted on pages 2 through 3 of his response brief concerning geofencing evidence without providing a single shred of proof whatsoever that his claims are true. Again, juxtapose this fact with a defense who has provided 126 exhibits to back up their claims spread throughout 3 Frank's notices. So it's fine and dandy and all that Nick McLeland said in his response to the third Frank's motion that, you know, the defense is just reading it wrong, and these people could be anywhere from 50 to 1,000 yards or 1,000 feet from the ping point. I don't know, but it doesn't appear that is necessarily the case. It appears that Nick doesn't know what he's talking about because he didn't have any facts or backup to bring his claims, which is what I said when I was reading through, like, where's the backup stuff? You know, where's the facts? Where's the evidence to back up all of this stuff? He hasn't put any of it in. Sorry. Gotta adjust my seat. My hips are starting to hurt sitting here. Anyways, all right, so let's move on. We're almost done. All right, 3 pages more. At this time, the state of Indiana has provided to the defense a map constructed by someone that shows that 3 phones were in the area of where the bodies were found, moving in and around and near the crime scene at a time that the unalivings would have been committed according to the state's timeline. Someone took the time to take data and construct that map using only 3 phone numbers and not the multiple other phone numbers that the geofencing data provided. For some reason, the author of that map focused solely on 3 phones. The coordinates provided by the state of Indiana do in fact provide the times that the phones were in the area, despite claims made by the prosecutor in his response motion. So he's like, Nick McLeland's lying to you. In his response motion, the state of Indiana claims that the owners of the phones found on the geofencing map in and around the crime scene were interviewed and then dismissed as suspects. The defense has requested the state of Indiana to provide any report, video, or document memorializing any and all interviews of those persons whose phones were found on the geofencing map. The state of Indiana still has not provided said information or indicated where such information may be found in the vast discovery. So you claimed that all these people were interviewed and excluded as a suspect. So where are those interviews memorializing those interviews? I mean, where are the police reports memorializing those interviews? We haven't gotten a darn thing about it. So this is the first time we're hearing about it because we don't have the evidence to back it up. The state of Indiana still has not provided said information or indicated where such information may be found in the vast discovery. The first the defense has heard that these people were interviewed is in the state of Indiana's response filed on April 3rd, 2024. The one that we just read in the video before this. All right, so until the defense can depose the correct geofencing expert and analyze the geofencing expert's reports, the defense can only base its conclusions on what the state of Indiana has provided to the defense thus far. The defense made it very clear in its third Frank's notice that it did not have any reports or information that contradicted its belief that 3 phones were in the area of the unalivings, but that the defense could be convinced otherwise once the prosecution provided more information on the name of its geofencing expert. Additionally, because the defense has no further funds for our tech expert, because they got no money, the reliance on the prosecutor to provide reports and to provide the name of the correct geofencing expert is even more vital. It should be noted that the defense is attempting to raise funds for the variety of experts needed for Richard Allen's defense and does not know if the tech expert can be afforded even with the money raised thus far. Geofencing is a very complicated discipline and requires experts to train the attorneys so that they can ask good, probing questions that will then help the lawyers and jury understand better the geofencing evidence. In his motion, the prosecutor assailed, that makes sense. You need to know what you're asking questions about in order to ask the right questions while the conversation is flowing. You don't want to just be set on your questions in front of you. You have to be able to shoot off of what they're saying in response and ask the right questions in regards to that. So it would take some training, I assume, on the part of the lawyer to learn how to ask those questions and learn. I give it to lawyers because they really do have to become experts in a lot of things, or at least, in their little minute detail of these cases, they really do have to become an expert. Anyways, in his motion, the prosecutor assailed the defense's attempts to understand the geofencing data. The defense freely admits that they are lawyers and not geofencing experts, and furthermore wish that they had accessibility to experts like the prosecution that could be called at no cost and consulted with on a moment's notice. Damn. The defense would ask this court to ignore the state of Indiana's claims unsubstantiated with any reports concerning its analysis of the geofencing evidence until the defense has had a chance to depose the specific expert that put the map together that the state of Indiana still has not identified. It's a simple question. Who put the map together? That is the person that the defense wants to depose. The defense implores this court to review the evidence provided in Franks 1, 2, and 3, particularly the interviews of Betsy Blair and Sarah Carbow, and then compare that information with the affidavit for search warrant, and then to consider the examples of concealment or attempted concealment of law enforcement and the state of Indiana, and to sign the proposed order that is also being filed simultaneously herewith granting our request for a Franks hearing. The defense is also sending to the court by overnight mail the following, which the court may not have for purposes of analyzing this motion, and would request the court to review the same before rendering its ruling. September 6, 2023, email from Nick McLeland claiming that Holman still does not know the identity of the Purdue professor and whom law enforcement may never be able to identify. Jerry Holman's September 22, 2023 report memorializing his 9/19/23 interview of Purdue professor Jeffrey Turco, in which Holman admits that he knew the possible identity of the Purdue professor as early as August 12th and no later than August 14th, 2023. A transcript of Jerry Holman's September 19th interview of Jerry Turco, an audio tape of Jerry Holman's September 19th interview of Jeffrey Turco, Jeffrey Turco's report from according to his deposition March 1st, 2017, and Jeffrey Turco's deposition from March 21st, 2024. Wherefore, the accused by and through counsel offers his reply to the state of Indiana response to the third Franks notice and would request the court to grant his request for a Franks hearing. Do you guys think she's going to grant them a Franks hearing? Let me know I'm going to put a poll in this video and I want to know from you guys if you think Judge Gull is going to grant the defense a hearing for Frank's evidentiary hearing to see if there is any hiding or falsifying information on the part of the prosecutor or law enforcement. It's going to be very interesting. I cannot wait to see her response because, I mean, how do you, they did her work for her. They just wrote it out and said, "Here you go. We put it all together. We laid it out in this beautiful timeline of events, and you have it all in front of you now. So how do you deny that?" I don't know. She's going to deny it, I think, but I don't know how she's going to deny it. I think there's too much there to say that they can't have the Franks hearing, but she can do whatever the heck she wants because she's the judge. So anyways, let me know in the comments below what you think. Definitely vote on the poll, and don't forget, like, this is not the last of my Delphi videos. I have another one coming up, so stay tuned, subscribe, like, do all those YouTubey things, please, so that you stay tuned with more videos on Delphi. I have another one that's going to be coming out soon about more people emailing the judge, emailing Judge Gull and asking her for cameras in the courtroom and to be more fair, to be less biased. So anyways, with that, I will leave you guys to it. Thank you so much for joining me, and I hope to see you in the next one. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.